court will recall that at the September 17th hearing, the court had before it a motion filed by Michigan Sugar Company asserting that no fines were owed because the use of the main aeration pond was allowed by the consent judgment. Eagle took a different position and said that the $270,000 fine was owed. The court directed a compromise. The court said, you know, you're going to say it's zero. They're going to say it's 270, but that's not going to solve the problem. And what you should do is you should go to mediation. You should explore ways to make sure either that this doesn't happen again or what the protocol is going to be if it does happen again. I think the court may have actually said when it does happen again. And the court directed that Michigan Sugar pay for the mediation and spend up to $270,000 to explore alternatives. And the key words there are up to. In fact, the court said during the hearing, tell me what's wrong with the ruling that they don't get a fine, but they have to look for alternatives because this could happen again. And the court specifically instructed that Michigan Sugar can spend up to that amount on the fine.
And can show us what they spent on
Absolutely
looking at options. So
itemize everything.
Well, okay, I'm going to stop you there. What's wrong with that? Where's the confusion?
Your Honor, may.
You may.
Thank you. I think, and with all due respect to the court's time, I think the issue with Eagle was we wanted to make sure that this wasn't, that this was truly, as the court said at the time, a situation where Michigan Sugar's feet were held to the fire, so to speak. What we didn't want was a situation where they could essentially come up with any amount that they wanted with no particular oversight, and that they could then essentially draft their own windfall, that it could be any amount at all. It could be $1,000 or $2,000 or $5,000. The compromise is.
Wait a minute, counsel. We know it's not going to be 2,000 or 5,000. It's going to be very expensive, and they can have an itemized list, which you can then object to, and we can have a hearing. What's wrong with that? If you want to put that specific language in, that's fine. There's not going to be a windfall because I set up to the amount of the fine. And if they only choose to spend 2,000 and they defy my order about finding the real solutions, then I double the fine. I will order a whole lot more because I can. So if my language isn't clear, do you have alternate language that you'd propose?
I think that language is perfectly fine, Your Honor. We just wanted to make sure that there was some sort of oversight mechanism to make sure that there was that.
I'm your oversight.
Yes, ma'am.
And I'm not very nice when people defy me. And y'all know that. If you don't, Google me. You got a problem with that, sir?
No.
Is your client planning to spend $5,000 instead of 270,000 or more? Because we got a real issue here. It's going to happen again. We know that. And I need real solutions with real chemists, environmentalists, or whoever you need. Right. We got that?
We're going to go to mediation. And if the solution we agree on is 300,000, we're going to pay it.
Great.
If the solution we agree on is 200, we're going to pay it. But if the solution we agree on is 200, we just don't think we should have to shell out an extra 70,000 just for a windfall to the state. Whatever we agree on.
When and if that all comes to fruition, come and see me, and I'm going to figure it out. Yes, I am your deciding factor. So do the right things, and hopefully you'll reach agreement. We have two smart attorneys. You're going to have a lot of smart people to work with. I don't want money wasted, but I also don't want the orders defied. And I think that this money is wisely spent on figuring out a solution than ordering a big fine and having no solution. So let's get where we need to. I'm available by phone. You can call me on weekends or evenings. You can do whatever it is you need me to do to help move this along. Anything else?
Can I present the alternate proposed order that we prepared?
Have you seen the alternate proposed order?
Yes, ma'am.
Are you in agreement with that, or would you like additional language?
Ma'am, I think we would ask for additional language as the court, sort of.
Then go in the back. See, there's a back room there. Go work out your language, handwrite it in. If you can't print nicely, I can. And then I want it entered today. It doesn't have to look pretty.
Yes, ma'am.
Great. Let me know when you're ready.
Thank you, Your Honor.
Thank you. That's all. Okay, which one's next? What? Well, you know, this is docket 253717CH, JCP Outstate Michigan LLC versus Rockland Farms and Ohio General Partnership. Counsel, your appearance for the record.
Brandon Frank here on behalf of plaintiff.
And I do not see defendant here. This is a request for a default judgment, and it looks like you properly served,
Yes, ma'am.
and they've not appeared or otherwise defended, and this was scheduled for what, is it 9:30?
9:30.
So it's 9:41. I generally wait 15 minutes, but I'm gonna sign this. Just don't leave till quarter two, and then I suspect we're good.
Yeah, the defendant is a defunct Ohio partnership that's.
Yeah.
I would be surprised if someone showed up today, but I will stay around.
Yeah, and just so we can, 15 minutes is good. It's raining outside. I don't know what the log jam is downstairs, security, so we gotta make you copies anyways. Court is signing the order. It does comport with what's been pled. Anything else we need to make for the record?
No, Your Honor.
Thank you.
Thank you.
And that would conclude this matter. That's all for this record. Matter.
Until 11:30 or until 10:30.
Really?
Unless,
Well, is anybody ready?
I mean, there were just pretrial conferences. One was
Are they
sheet
gonna
on.
do a plea?
We got a form on one there. I think one already has a bench warrant.
Do you want to do that one?
Yeah, we have two cases that I think are gonna be bench warrants, we can do real quick.
Yeah, let's just do those.
I need to
Are any of these pre-trials gonna plead?
file.
We weren't able to get in touch with Emily as long, so.
So
I'm sorry, Judge, what?
Are any of these going to, we have time to take a plea instead of set nothing?
No, Mr. Kaplan's just informed, Mr. Pete is already in bench warrant status, he didn't here today.
Okay. Let's,
and then is it Norris is the other one?
Norris is not here, but we can't, Ms. Robinson is filling in, we can't show that he was made aware of the date,
Gotcha.
so I'm not asking for a bench. warrant.
How is it we can't show? Isn't there in the register of actions? Isn't there a service?
So he was actually in custody and then recently bonded out, I wanna say last week sometime. We got in touch with his mom, but we weren't able to get in touch with him to let him know of the date.
Okay, so I guess we'll send them a date and reset it. All right.
Your Honor, he is supposed to be being screened for mental court, so I think that's gonna resolve itself anyways.
Okay, so I'll just give you you want a December date or a January date?
January?
We're gonna go on the record on it.
Yeah.
Okay.
All right, this is docket 255997 FH, People of the State of Michigan versus Ricky Dwayne Norris. Counsel, your appearance for the record.
Morning, Your Honor, Natalie Maycomber on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Norris.
And as I understand, Mr. Norris is not here. We're not sure he received notice because he was incarcerated and he's being screened for mental health. So I'm going to move this pretrial to January 21st. Would you like it at 9 or at 1?
9 a.m. please.
That
That's
work?
fine with me, Judge, thank you.
All right, that should be plenty of time to get him screened, and then if you need to reschedule him so he gets pled in and transferred over to mental health earlier, that's fine, but this should give him enough time to get screened and all of that, because we have holidays coming up, so I could make it earlier, but I don't know if everybody's backlog is, so as long as you are all good with that, we'll send him a notice to his mother's home.
Yes, and we'll continue to try to reach out to him as well.
All right, thank you, that's all for that record,
Thank you.
and then we have
Hold
docket.
on.
Yep.
Okay, finish.
Okay. Okay, then we have docket 256003, FH, People State of Michigan versus Johnny Ray Pete. Counsel, your appearances?
Good morning, Your Honor. Natalie Mecklenburg, on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Pete.
And this is a pretrial conference. Where is your client, ma'am?
Your Honor, I think he's already in bench warrant status. He failed to report to pretrial services, so.
All right, bench warrant, bond forfeiture, and we'll let you know when we pick him up. Does he have any other case, or do we know where he's being held in any other county?
He is not being held in another county now.
He has no other cases with us, Judge.
All right, well, I'm sure law enforcement will find him. Anything else for this record?
No, Your Honor.
No, Your Honor, thank you.
Thank you. And then what did we do on Greenwood?
There was a form.
Oh, I signed that. So that's just been set.
Yeah.
Okay. And
So we don't need to go on the record, on any of those, we're good.
no, but what about, who's here, who's coming over on, what defense counsel is on,
And
Anthony.
Jared also,
but he's not here,
No.
Bill's not here
okay? So is anything ready to go that we can take early or no? No,
yet.
okay.
Judge.
Townsend's also gonna be a form.
I successfully stalled long enough that I think you're your window. Super.
Thank you, appreciate it.
You too. Jones for you. I will
Yeah.
print off the last pre-trial sheet. Yep.
He's gonna come down. He's just for that.
Stand in and show the time.
After,
Time?
yeah.
Yeah.
See your client.
Yeah, that's great.
So at 10:30, we can just go.
All right. I guess I'll be back on this in a little bit.
Yeah.
They did.
We're back on the record on docket 17-727 CE. Both council have reappeared before this court and have amended the proposed order to include under item 5 language. So now it reads, defendant shall provide plaintiff and the court with a detailed accounting subject to objection and judicial determination of how funds were used towards actual implementation of alternatives for prevention and management of high-strength wastewater to, from, or between the main aeration pond and outer ponds at defendant's Bay City facility. Both council have initialed it. I initialed it. I signed the order. Is there anything else for the record?
No, Your Honor.
There's not.
Thank you
Thank you.
very much. for
Happy
the
Thanksgiving.
agreement. Happy Thanksgiving.
Thanks,
Always a
John.
pleasure.
Likewise. All right.
You'll receive your copies in just a moment. That is all for the record.
Thank you.
Great. Just have here. All right, the court has shown both counsel this map that was provided by JSG. Let's just go to hearing today and make a record, so this doesn't happen again. Sir, counsel, are you awaiting further arraignment?
Yes,
Is there going to be a plea or hearing?
Your Honor, I believe Mr. Anderson will admit to the court what happened. He will admit to violating that and will offer an explanation as to how it occurred.
Is that correct, sir?
Yes.
All right. How do you plead to violating the no contact order by virtue of appearing in the zone that was protected on November 22nd, 2025 within the exclusion zones of the protected person known as Anaya Williams and then as of Miles Washington? How do you plead?
I admit that I went through the zones.
So is guilty, not guilty, or no contest?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No,
Did anyone promise you anything that caused you to plead?
no,
You clearly understood that you were not to be within 2,000 feet of their residence or of them, correct? Regardless of where in the community, correct?
yes,
And you drove, even if it was only for a couple of minutes, you drove through both of those areas so that you were near both victims. Is that fair to say?
yes.
And you knew where they lived?
No,
You don't know where they live?
no.
Curious that you did it on the same day. But I'm going to accept a plea and find that you're in contempt of court and that you pled freely, voluntarily, knowingly, and understandingly. You've been following it for a year and a half, and suddenly we have 2 violations, and it is a bit curious. So, counsel, I'm going to let you question your witness as to what was going on.
So, Mr. Anderson, do you remember where you were at or where you were traveling to that day on the afternoon of November the 22nd?
Where I was going to,
Yes, do you recall?
I just know I was going to a funeral. I wasn't driving.
Were you a passenger in the car?
Yes,
Okay. And whose funeral was it?
it was my best friend's funeral.
What's the person's name?
Davion Lincoln,
And where was this funeral to occur at?
on the north side, the church on the north side.
You remember the name of the church?
No,
You remember the approximate time of the service?
no,
Was it just you and the driver in the car, or were there other people?
it was other people.
Did you end up attending that service?
Yes,
And did you or the vehicle you were in make any stops along the way?
no,
Other than, I'm presuming that maybe the car occasionally stopped for traffic control devices such as red lights and so forth?
yes,
Did you stop at anybody's house or any businesses along the way?
no,
Either, okay. And did you have any contact or attempt to have any contact with the protected parties in this case on that day?
no.
I have no further questions, Your Honor.
Did you go home a different way?
I don't know.
Did you go home the same way? Do you know?
After we went to a repass, and then I went home.
Okay. On behalf of the people, questions?
Thank you. We have no questions, Your Honor. We'll reserve our comments for sentencing, please.
All right. On behalf of the people, what would you like me to know?
Your Honor, thank you. I think the court has given the people ample opportunity to be heard, and the court understands our concern. They are legitimate concerns. So what we are asking, Your Honor, is first of all, to fashion a sentence that takes into consideration the people's concerns. If you would like to let this defendant out pending his trial, we understand that. We would ask that all Bond conditions remain in full form and effect, Your Honor, but understand that this defendant is on a razor's edge if in fact there are any other violations of exclusion zone or contact with victims or the eyewitnesses pending trial. The defendant will be remanded pending trial in this case.
Thank you, Your Honor. I'm mainly going to incorporate my prior comments, and I would ask the court to take those into consideration. Again, I can understand the concerning nature, and I can perhaps even appreciate how, looking on the outside, looking in, how this might appear. But again, Your Honor, absent any other evidence that Mr. Anderson was attempting to do anything nefarious with either the witnesses or the protected parties in this case, again, I would ask the court not to draw that conclusion. Again, these were very brief time durations of these exclusion zone violations. And also, Your Honor, this is not the first time that this case has been set for trial. It's been set for trial. We've been previously told that we were expected to be ready to go, and for reasons it's been adjourned. We didn't have any exclusion zone violations or any violations of the no contact order at that time. So again, Your Honor, I'm just asking the court to see this for what I think it appears on its face to be. This is Mr. Anderson who found his way into the exclusion zone for a brief amount of minutes. But I think he truly does get it now, and I think he understands just how short of a leash he is going to be on as we are very vastly approaching trial. If there's going to be any other further violations of anything, he's going to find himself sitting in a jail cell until that trial occurs. So again, Your Honor, I'm going to ask the court would admonish Mr. Anderson, continue him on his bond, sentence him to the time that he has served on this violation, and continue his bond on its current conditions and any other conditions that the court may feel are necessary to alleviate any further concerns. Thank you.
How long has he been in jail?
Since the 22nd, since this occurred, so I believe this would be his 5th day. Fourth day.
Sir, anything you want me to know?
I just wanted you to know that I was just trying to get to the funeral. I did, being to go through the zones. When I entered it, my tether started going off, and that's when I noticed that I entered the zone, and I was just trying to get away from it real quick to get to the funeral. So I know I messed up. And
Do you have a driver's license?
no,
Okay. So you rely on others to drive you?
yeah,
Whoever's driving you, you need to advise them of the exclusion zone and that they may have to go out of their way. All right, I am going to give you 4 days jail with credit for 4 days, but if this happens again, I'm just gonna have to have you sit in jail, okay? It's interesting, as the people have pointed out, it's not by one, but by 2 homes. One seems plausible, but 2 seems pretty incredible. So you have my warning. I'm reinstating your bond and bond conditions, keeping the 2,000 feet. Don't violate again.
okay,
Get a map, use reliable people for driving you, and I will see you for trial December 5th at 9 a.m. I believe you're first up. I'm not sure though. Counsel, do you know?
We are first up on the 5th, Your Honor, yes.
All right, we are ready to go. You're ready to go?
Yes, I am.
All right, we'll see you at 9 a.m. on that day, sir.
If you guys could just add your instructions to me and provide that there, that'd be fantastic.
We will, thank you.
Thank you. That is all for the record.
Your Honor, I apologize. May I speak to, I'm the victim's mother. So I have, bear with me. Keisha Moore. So Davion Latham is my son.
Go ahead, back down.
And he was legitimately at my son's service.
Okay.
I just don't want you guys, because you guys, I heard him say it's suspicious. My son was killed on the 11th.
I'm very sorry.
he was not trying. He legitimately was trying to do. He carried my son out. I feel that it was a blessing that all the boys were there because they could have been out doing something, you know, that they should have any business doing. So I would just ask, if you guys want to blame anyone, blame me.
Well, ma'am, what happened is because of the violation, he was picked up. I'm letting him out, everything's reinstated, all right? And I'm terribly sorry for your loss. I can't even imagine. I appreciate you being here, especially with everything you're going through, but he'll be home, but it is a good reminder for him to stay out of the zone, because we can't have the appearance that something's going on, all right?
I appreciate it.
Okay, thank you for letting me know.
Judge, can I approach?